This is Ask Todd on the Financial Exchange Radio Network. If you have an existing estate plan or are in the market for one, Todd Lutsky is here to answer your questions and help you plan for later life. Ask Todd is presented by Cushing and Dolan, serving Massachusetts and New England for more than 35 years, helping families with estate and tax planning, Medicaid planning, and probate law. Visit CushingDolan.com. Now, here's Todd Lutsky.
Well, we are now joined by Mr. Lutsky from the law firm of Cushing and Dolan. The segment's called Ask Todd because it's your chance to ask Todd your questions about your estate plan live on air. The studio line here is 888-205-2263. That's the number to call if you have a question that you'd like to ask Todd Lutsky. Again, that is 888-205-2263. Phone lines are open, so get calling so that you can get in line to ask Todd your question. Mr. Lutsky, how are you today?
I'm doing good. That was the first question.
I always get to ask the first one.
I know, you do.
I do. I'm kind of going through a little bit of an existential thing.
Existential.
I'm trying to find my place in life. I've always wanted to be a Gregorian monk.
Yeah?
But I feel like I was never given the chance.
I get it.
So I'm working on it.
You keep trying.
Let's talk a little bit about irrevocable trusts. One of the major questions that I think people have regarding the usage of an irrevocable trust is, well, what does this mean I'm giving up in terms of my ability to use my money the way that I want to? Can you answer a little bit about that question in terms of the restrictions that an irrevocable trust imposes on its users or grantors?
So, and I think that's a fair question because most people think that there's a ton of restrictions. But the fact of the matter is there really isn't. And the good news is that you can do a lot more than you think. So let's maybe run through just a few of them. So your money, you mentioned. You put the money in the trust. Obviously not IRAs or 401ks, but you could transfer your investment portfolio in the trust. And people say, well, am I going to have, investment limitations, or can I not invest in the breadth of the market? Well, no, you can invest in anything you would invest in individually. And when I say you can invest in, obviously, certainly welcome to talk to your financial advisor. And let's say you want to put in an investment portfolio and you want to continue to manage it. You want to continue to decide what gets bought and sold and work with your advisor. You are able to do that even though you're not the trustee. Again, I don't love for you to be a trustee. And so you still have that ability. You still have the ability to sit back and collect all the income that your portfolio generates. So you certainly want to be able to do that. You also can, even though I said you're not the trustee, you're kind of directing the trust in terms of what needs to be done because you have the power to remove and replace the trustee. So lots of control in that regard. And so I really feel like you have more control than you think you're giving up.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. If you have a question that you'd like to ask Todd about your estate plan or maybe your lack of an estate plan, this is your chance to do so. The studio line here is 888-205-2263. Again, that is 888-205-2263. Todd, when we talk about an irrevocable trust, if someone decides to use one,
yes,
how does it impact their tax situation?
That's a great question because most people believe that when you're dealing with a trust, you're in a higher income tax bracket. And with irrevocable trust, that can be the case, but not for this one. There's a spectrum of where you can fall on the tax world. These trusts that we prepare at Cushing and Dolan for nursing home protection are what we call grantor trusts for income tax purposes. So you're considered the owner for income tax purposes. And whether, back to my investment portfolio, whether you take the income, the interest and dividends from the trust and put it into your possession or not, it's still going to be picked up on your individual income tax return. So you are in the same income tax place that you were before you created the trust. Again, whether you take the money or not, you will file a separate income tax return. So if you're thinking you're not, you will. It'll be a 1041, but it will pay zero income tax. Everything just flows out onto your personal return.
Talking with Todd Lutsky from the law firm of Cushing and Dolan. Again, the segment's called Ask Todd because it's your opportunity to ask Todd a question about your specific estate planning situation. The studio line here is 888-205-2263. We're going to take a quick break right now, but when we come back, it's right to your questions. We still got a little bit of space in the phone lines, so that number again is 888-205-2263. Quick break. Your calls after this.
Ask Todd with Todd Lutsky every Wednesday at 10:30, only here on the Financial Exchange Radio Network.
As promised, right to your questions with Todd. First up, we've got Jerry in Connecticut. Jerry, you're on with Todd Lutsky.
Hi, Todd.
Hey, Jerry.
I've got a question. Now, I have a will, but I don't have a trust.
Okay.
Now, I wanted to know if I had a revocable trust, does it avoid probate in Connecticut?
So revocable trusts in general avoid probate in all states, I would say, because a probate asset is an asset you die owning in your own name. Everybody says, how else might I own assets if I don't own them in my own name? Well, a revocable trust is a great way to do that. Houses, investment portfolios, revocable trusts avoid probate. So do irrevocable trusts. Did that help?
Okay, now, yeah, that does help. And so the investment firm that I deal with plus the home should go in there. Now, in my investment firm, I have TODs on all my accounts, transfer on death in Connecticut.
Yep, that'll avoid probate.
That'll avoid probate. So, okay. But would I still put that in a revocable trust even though I have TODs?
I think what we need to get at is what your overall question is. If your goal is to do estate planning, if it's just to avoid probate, joint ownership, TODs, transfer on death, designated beneficiaries, all that stuff avoids probate. But to me, it doesn't really do estate planning, right? It depends how you want to leave your assets to your family. Do you want to control them? Do you want to protect them from future divorces of the family members that you're leaving them to? Do you want to, skip a generation and provide generation skipping tax planning? It depends what you're trying to accomplish. But, generally, if it's simply to avoid probate, I find the easiest way to do it is just throw everything into a revocable trust and not run around trying to do this. But to try to, put an account, a joint account, a child's name on each account or whatnot, who knows if you're treating people equally or not. So was there more of an estate planning question here or just a probate avoidance question?
Basically, it's a very simple estate plan. We just have a son, so it's not very complicated. And there's no grandchildren. But now I have two properties, one in my wife's name and a secondary home in my name. Should they both be in both of our names?
Again, my thinking is everything should be in trust. And that's just
okay.
Across the board. Put it in trust and leave the trust to decide how you want your assets to get to your child.
Okay. Well, thank you very much for your help. I appreciate it.
You're welcome. Thank you. And so, folks, this was an interesting question because everybody wants to know how to avoid probate. So it's not just Jerry here. And I think avoiding probate with a trust is an easier way to go than trying to put names on accounts and treat everybody equally that way. But Jerry didn't mention anything about trying to protect assets from the cost of long-term care, and it may not be an issue for him, but it might be for you. The guide we're dealing with today is unlocking the power of irrevocable trusts. And folks, this is 30 years almost of gathering questions from clients, question, answer, helping you understand how these trusts operate from, how the taxes are paid, how probate is avoided. Can I live in my house? Can I sell my house? Can I change beneficiaries? Who can be the trustee? How much power I really keep and how they work. If you've ever wondered whether a trust like this, an irrevocable trust, is right for you, this guide is for you. Call and get it, 866-848-5699 or legalexchangeshow.com. You can download it there. Unlocking the Power of Irrevocable Trusts, 866-848-5699 or legalexchangeshow.com.
Todd, I've got another one queued up for you here. Let's go to Eric in Springfield. Eric, what's your question for Todd Lutsky?
I'm the executor of an estate for my brother. Can I purchase a condo in a trust?
Well,
or rent it.
if you're the executor of the estate, is there a will involved, I assume?
Yep.
And in the will, does the will say what happens to the assets?
I'm in charge of everything.
But but more importantly, does
he gets half the estate.
does the will? So the will says upon the death of the decedent, in this case,
Yep.
right? The assets in the estate get divided equally and paid out to the individuals. Correct?
It doesn't say paid out, but I'm in charge of how they're dispersed to.
But
brother.
but when you say how they're dispersed, does it say is there a trust created inside the will, or does the will say simply give it to these people, or does it tell you how to give it to them?
It says in trust for the benefit of my son.
Ah, see, so that's the issue. Without me reading that document, it's very hard for me to answer the question, but I needed to get to that point. So it sounds like in this case, a trust was created inside the will. That's oftentimes called a testamentary trust. A lot of folks don't get that. Call it a will trust if you like. And so you need to read the language in that document and see what it says. If it says hold the asset in trust for the benefit of your brother, in this case, then yeah, you may be able to, you as the executor or probably the trustee of that will trust, have powers like how do I invest the property? How do I make the assets in the trust productive? And if one of the ways to do that is buying a house so that he can live in it, I would say you're probably allowed. I don't want to speak out of school. I haven't read it, but please give it a read, check it out, and see what your powers are in terms of how you invest those dollars. So I hope that was helpful.
Todd, I got a question for you just when it comes to irrevocable trusts in general and how they operate again, just to kind of get back to that topipic.
Yes.
When we talk about some of the terminology that gets thrown around, is there a difference between the term donor versus grantor? Do those mean different things, the same things, or is there some nuance there?
No, I would say donor, grantor, settlor. These are all terms that you would see as what I like to call the person who's creating the trust. Obviously not the attorney drafting it, but it's the person creating the trust, right? And so it's usually the mom and dads of the world. It could be the Jerrys of the world in this case, or the Eric of the, if Eric was to create the trust. It's the person who's creating the trust. Probably in Eric's case, it would have been his parents.
And when you're talking about placing any assets into one of these irrevocable trusts, is there any consideration of any gift tax or any of those exclusions or anything like that when you're going into one of these trusts?
Yeah, I think that's probably one of the more important things to consider when you're creating an irrevocable trust. Many people think that because it's irrevocable, somehow I've given the asset away. Make sense? I haven't. These trusts, at least these trusts. Now, there are other irrevocable trusts that do cause completion of gifts and create, as you might be thinking, gift tax situations. In this case, it's an incomplete gift for gift tax purposes because we give the donor that power to change the beneficiaries of the trust during their life. Another really important power that is laid out in this guide. So because of that power to change the beneficiaries, it makes the gift incomplete. No gift tax return really needs to be filed, and you just transfer it and move on.
Mr. Lutsky, thank you so much for joining us today.
Always a pleasure.
The views expressed in this segment are solely those of Cushing and Dolan. Armstrong Advisory does not provide any legal or tax advice. Please consult with your legal or tax advisor on such matters. Cushing and Armstrong do not endorse each other and are not affiliated.